Pretty close to 1 o'clock. So, tēnā koutou katoa. Welcome everybody to this council meeting. Welcome to councillors, welcome to staff, welcome to consultants. Great to have you all here. We'll just run through the normal steps leading on to the agenda. As far as I know, there are no apologies. Confirmation of the agenda. I understand there's no additions or changes. Conflict of interest, just noting when, and I'm sure we will, discuss carbon forestry. You may be aware or may not be aware, but through my family trust, we do own 2 forestry blocks on our property, but they're not registered for carbon credits. So I will stay put. I have sat out of other discussions previously, but I feel this is fairly focused on carbon forestry rather than forestry in general. Carmen, you had a comment as well.
Yes, but I think I would be better to stand aside. We have carbon credits on forestry blocks, and I think it would be better if I was to stand aside. Thank you.
Any other matters to be raised under item 3, conflict of interest? Brian?
Yeah, just under conflicts. I mean, I too am involved in the forestry block. We don't have carbon credits, but for the life of me, this is about the RPS. It's the bigger issue.
Yeah. I'm just preempting.
Carbon forestry is like, what, 0.01 of what we're going to talk about and refer to today.
Can you hold back on that discussion? But I understand where you're coming from. Okay. Nothing else on item 3, conflict of interest? The resolution to exclude the public. So I'll move that the public be excluded under the Gorma sections 48(1)(a), 7 bracketed 2(f), Roman numeral 2, and 7 bracketed 2(g) from discussions of the following item being the RPS notification. Have I seconded? Carmen, any discussion? Hillary? I'll just get you to turn your microphone on. Thanks, Carmen. Thanks, Hillary.
Right, yeah. I think if there is some pressure on us at this point to actually finish the day with an adopted RPS, quite significant pressure, I think it's important that the public understand why we're choosing to do what we turn out to choose to do today and hear the arguments we're having concerning that. As regards the legal advice we may be given during the course of that, I think we can go out of public and receive legal advice and come back into public again. So I don't see the legal advice as a barrier to that, but I think it's important for it says in one of our papers here that in an option, and it talks about why the option might be good or bad, and it says this is a public planning process, and I think this is the nitty-gritty of the part of the planning process where we're deciding, and people have a right to know what's motivating us as we decide, and they also have a right, if we're getting general advice about why the choices we make might be appropriate or not appropriate, what we've made of the advice we've given. So.
Thanks, Hillary. Can I just check with Sarah? The meeting is being recorded, so at some date in the future, a decision will be made under normal practice if it's appropriate to release the video, recorded video, to the public.
There is that opportunity, whether we would or not, would be something we would consider in the future.
Thank you. Gretchen, then Kevin.
Mine is whether or not we could actually have legal advice at this moment on the pros and cons of moving into public excluded. Just I think that there would be options available to us as a council moving forward and what our stance would be. I don't know what the discussion might be, but I'd like to have some legal advice on perhaps why we are in public excluded and why that's felt important, and the pros and cons of that approach.
Kevin
This will
and-
be adding to that question, will be answered the same, but it would be if we did in fact go to publicly inclusive, that we include the public, could we adjourn appropriately to seek legal advice on any matter?
Michael, assume
Well, no,
is
that
yours
that
is a
question
quick.
can be answered first and then I'll.
Okay.
Yeah.
Okay. Sarah, and then
Okay, yep. So, the reasons why we've recommended public excluded are twofold. One, to maintain effective conduct of public affairs through the protection of such members, officers, employees, and persons from improper pressure or harassment. And two, maintain legal professional privilege. And we do have our lawyers here today. So they are the two areas that we have identified as being relevant. You have also some precedent where you have dealt with other plans and policy making in the same way, i.e. public excluded. I think personally, if you want to have an efficient conversation, the ducking in and out of public excluded for legal advice will make for a very protracted process and potentially one that isn't that helpful for the public to access if they're party to some but then not others. And so, you know, you might want to think about that. But they're the reasons why. You can, of course, opt to go down that track, but I think you should make a decision to go public excluded. That's our recommendation, and I think it's appropriate.
okay, we've got Alistair Logan and Simon Anderson from Russ Dowling.
I'm just trying to get Peter Kay online as our corporate lawyer who gave us advice. So
Oh, sorry.
we're just trying to get Peter Kay online. It's not these guys that are giving us
Peter
advice.
Callagher,
Peter
Our
Callagher.
Oh.
legal counsel.
Sorry.
No,
Okay.
did you hear that too? Must be Australian accent, was it?
We've got some lawyers in the room
Yeah.
who their clocks are ticking, and I just wondered whether we could.
Very slow.
Lagoima Act, it's not the RMA. It's the Lagoima Act.
It's the
so
Lagoima,
just-
that's
it's a
correct.
different piece of data.
Well, if there's a specific question you want to put to either Simon or myself, we'll address it. The decision is for you. You don't have to go into public excluded session. I don't know how it's envisaged that the discussion will evolve this afternoon, but there is a significant practical problem if legal issues are interwoven with quite a long discussion about provisions in the RPS, which really makes it impractical, I think, to have a useful type of discussion if you're flicking in and out of public exclusion.
If we were.
Yes.
I'll just check with Gwyneth. No news from.
Amanda.
Okay. Cool. Michael.
Can I just deal with this? First of all, the purposes of it is the Local Government Official Information and Meetings Act of 1987 that relates to this issue. And far more important than individual sections and placed in the purposes of the Act is to increase, and I quote, progressively the availability to the public of official information held by local authorities, and then to promote the open and public transaction of business at meetings of local authorities in order to enable more effective participation by the public and promote the accountability of local authority members and officials. Now that's the overriding purpose of that Act, of which the section to exclude is later on in the Act. And I'd have to say, on the basis of these two notifications here, I can't see that there's going to be any improper pressure or harassment of our staff on this issue any more than any other issue or staff paper that is brought to this particular body. On the second one of maintaining legal professional privilege, this isn't, can I just advise, a catch-all. That professional privilege information would be if there was something consequence upon it. For example, there were commercial negotiations, there was individual personality or principles involved or something like that. If I ask Mr. Logan in public what that particular view would be on this issue, his information isn't automatically private. And indeed, we have used Mr. Logan in the past, in my time of about 4.5 years, he has talked in public to this particular body. So nothing that he says is automatically private. It has to be generated, therefore.
Okay,
So I would argue
right now we haven't got a motion on the
okay, then
table.
I'll move one.
Oh,
So I thought, Hillary, you raised the issue.
Okay. Well, then
I didn't hear that you're moving something, but
I thought you had moved
You had
that
moved and
number 4 and Carmen and seconded it.
I beg your pardon. Yes, I did. Sorry.
Right, so
Now
then
you're
we're speaking
to that
against
motion.
it.
Beg your pardon. So
Okay.
you're speaking to the motion, Michael.
So I am, thank you.
Sorry.
That's all right. So therefore, I would argue both reasons don't apply. If we go to, during the course of the discussion, let's just assume that we're going to have this meeting in public. If we go to Mr. Logan or Mr. Kelleher or any other legal person for advice, will that meet the test contained in Lagoima of excluding the public? In other words, will there be persons whose career position is threatened? Will there be something that's commercially confidential? Will there be something that we receive that may give a legal advantage to other persons? And I would argue in this particular case, no, because we're dealing at pretty high-end issues. Nothing specific that will affect individuals or allow them to gain a legal or commercial advantage from this discussion. So for that reason, I don't see anything that Mr. Logan's likely to say, unless he would like to raise it, as being necessary to meet the criteria established by the Act.
Yeah, just hold that thought. I'm mindful that we're in a state of flux because we're waiting for Peter to arrive. And I just, rather than having a debate and heading around the table before we've
adjourned at the moment too.
Correct. Would you like to move that way?
Yeah, I'll move. So move.
Seeing so we'll adjourn until Peter Kelleher is available. Whether is he coming via Zoom or physically coming?
Yeah, sorry, I've just spoken to him.
Thank you. So we'll just stand adjourned.
Yeah, Mr. Chairman, can I be able, as soon as to ask a question? I don't want to argue. I want to ask a question.
Stand adjourned until Peter Kelleher is available. Thank you.
I could actually answer the question.
Yeah. Could we see if Mr. Logan would be able to answer it?
I didn't realise it was that close.
I'm trying to follow a good process. And Peter,
We haven't instructed Alistair to answer Lagoima questions. Our lawyer who deals with Lagoima is Peter Kelleher.
Yep. Perfect.
That's fine.
That's good.
all good. We're adjourned.
They will stay there forever unless it's a designated spot.
Okay, welcome back, everyone. We are now reconvened. Welcome to Peter Kelleher on Zoom. I just want to we'll just pause for a moment, Peter. We'll come to you in a few minutes, but I want to go back to the resolution that I moved and was seconded by Carmen, that it includes the external parties that will remain in the room for the MPS notification paper if it's held in non-public. Include Sandra McIntyre and Michael Bathgate from Akaha. Welcome both. Alistair Logan and Simon Anderson from Ross Dowling. Felicity Boyd from Insight. And Peter Constantine from Playwright. And also Liam, sorry, I can't remember Liam's surname, but
Gladding.
He's staff.
Gladding. Thank you. Now, I'm going to go to Michael Laws first. I want you to but in a
Okay,
concise
Peter,
way.
are you there? Can you hear me?
Yes, we can. Thanks, Councillor.
So basically, the argument contrary to this one is that the Lagoima Act of 87 sets out in its purposes, as you'll probably be aware in 4A, the Opens in public transaction of business at meetings of local authorities. And that is the primary purpose of the Act. The rationale behind going into private today is one that there will be apparently a danger to officers and employees of the ORC were this matter to be resolved in public today. And the second is to maintain legal professional privileges, which I've argued is not a catch-all phrase. You can receive legal advice without it necessarily being privileged, and it would appear to be in this case today. So I've questioned the first one, and I've suggested the second. And I think Marion's got a question for you as well.
I'll go to Marion once. Do you
Sure.
want to pose your question now to Peter, Marion, or is...
Yeah, I
Okay.
wouldn't mind, please.
Thank you,
Peter.
Marion.
Sorry, Peter.
Right.
Can discussions and speeches in today's meeting, in this meeting, ever be used as examples of what we intended when there is a debate over the clarity of the RPS? I ask that, you look really puzzled, because
Sorry, this is an Alistair Logan question, not a Peter question, isn't it?
No, did you keep,
Oh, okay.
you finished? No, all good.
you've taken
you
over the chair recently.
Marion, sorry, you finish your question. And
yeah,
then we'll go
thank
to
you.
Peter.
I'm asking that question because in first readings of any legislation in the last 30 years, ministers have had to read from a script because those speeches are used in the High Court to determine the intent when the intent in the legislation is not clear. And that's what I worry about a wee bit.
Peter, if you're uncomfortable making a comment on that, Marion's question, I will go to Alistair after you've commented on Michael's question.
Thank you. I guess the 2 points which, or the 2 grounds I understand being raised is to maintain the effective conduct of public affairs through the protection of members, officers, employees, and persons from improper pressure and harassment. My understanding from the information I provided earlier was it was regards to the protection of members. The second element's been the legal professional privilege. I understand that legal advice is going to be given this afternoon regarding the paper. I guess the overriding important point to bring across here now is it's the council itself that chooses whether to hear these things in public excluded or not. It's essentially the council's decision on whether the paper is going to be heard in public excluded or not. Those are 2 grounds that are relevant and may be applicable, but the choice is with councillors in terms of where this paper goes forward.
Thank you.
And as for sorry.
Okay. No, you go, Peter.
And with respect to Councillor Hobbs's question, maybe more appropriate with Mr. Logan being there and familiarity with the content that's before the council, that whether he can comment on Councillor Hobbs's query.
Yeah, you go for it.
Sorry. Could I just add to your question, please, Councillor Hobbs? Could you also address for us, Alistair, the opportunity that staff advice given today could then be used when staff appear in court?
Thanks, Alistair.
Right, well, I'll pick up on the 3rd and 4th questions then. In practice, this is a distinction between the way in which parliamentary legislation is dealt with as opposed to resource management instruments. It is quite common for reference to be made to parliamentary materials if there is difficulty in interpreting a statute. And I've 30 years of the RMA being in existence, I'm not aware of any case in which there has been reference in the Environment Court or Superior Courts to what councillors or members of staff might have said they intended when they notified a regional policy statement or a plan. So I don't think there is any assistance derived in practice from what elected members might have intended about a particular provision and particular policy statement or a particular plan when it comes to interpreting and applying that document down the track. It is quite conceivable, and this is going to the Chief Executive's question, that anything said in this forum could be raised in subsequent stages or hearings about the proposed regional policy statement, either to assist the council or to more likely try and embarrass it. But that in itself is not a reason given in the Act for holding the meeting in publicly excluded session. The only relevant ground in that respect is legal professional privilege, and in that that applies to any communications between the council and its lawyers. The privilege is the council, it's not the lawyers, it's to protect the council, not the lawyer. And it's a privilege which, as Mr. Keller has indicated, can be waived by the council.
Thank you. So I've got Brian and then I've got Hilary now. Just clarify these questions for Alistair.
To be honest, I'm not quite sure who the question is actually for, but my question is that if a motion was to be passed to go into open, could it be subject to, emphasising that staff or lawyers, whoever, have that ability to seek an adjournment or to move into a private session?
Just to answer that.
I mean, like, all I'm saying is, if they felt uncomfortable, they would say that they're uncomfortable or for whatever reason.
So the decision still sits with us.
It does. I mean, what I would say is I think that we will think differently about how much advice we are prepared to give you in a public setting, because we don't know what your questions are. So we haven't been able to prepare for them. Sometimes we try to help you when, we don't have everything that we might benefit from in front of us. But if we're in public, I think we will exercise caution.
Cool.
Thank you.
Thank you. Hilary.
My question speaks sort of directly to that. Is there any legal distinction between what staff advise us in non-public and what they advise us in public? In that if we advise something by the staff and are encouraged to take their advice, which in a normal course of events we of course would want to do, that they gave us that advice behind closed doors wouldn't make it any difference to if they gave it publicly. We may alter our behaviour because we're told something. That advice, is there any way that makes it different if it's said behind closed doors than if it's said in public?
Is that a question for Alistair?
Yeah, it is. I'm not sure he understands.
No, I don't understand the question at all.
Yeah, and he doesn't want to comment on it.
Well,
what were you saying?
Yeah. Why I'm asking is that I'm presuming that anything that the staff advise us to in non-public, would be the same thing they would tell us in public. If it's different, can that be challenged in any way, or we just assume that, the assumption is that there's something different about what we would hear in non-public, possibly.
Well, I don't think what you're asking is a legal question. I think that
It's not
it's a question for the staff.
Okay. Sarah?
What I was meaning before is that we never know what your questions are. Exactly.
You don't know.
And so when we're in non-public, you tend to adopt a less formal engagement, and our ability to be free and frank with you means that sometimes we are more comfortable in giving you our best guess than we might be if we're giving that as a public answer that later the public rely on. Do you know what I mean? I'm not saying that we're being difficult. I'm just saying that sometimes we have an engagement that's a bit more free-flowing and a bit more free and frank. In a public setting, we need to be more circumspect because the public is also hearing that situation. So it's important for us that we are very careful about the advice we give in a public setting so that it is really accurate, as opposed to where we can say, well, you know, we kind of think this, but, you know, maybe we could think about such and such. We probably wouldn't go down that track in a public setting. So it's just the extent and detail, perhaps, of the discussion.
Okay, I don't want this to drag. We've spent half an hour on this already, and it's not about time. I realise that. But are there any more questions for either Peter or Alistair? And we'll just go back to the motion and focus on that. No more questions? Can I just...
Sorry,
No, I've made mine.
Okay. Can I
Mine
just
was a procedural matter.
make a couple of comments? Call me conservative or cautious or whatever. I'm comfortable that we stay in non-public to have the open and frank discussion on whatever matter we need to talk about and be able to receive the appropriate professional legal advice during those discussions without prejudice, etc., etc. On the basis that at some point in the future, a decision will be made about how much of this recording can be made public. And just noting that the recording will only be oral rather than the actual YouTube, because that's not possible to jack that up if we end up in, that's not a reason, but just so you're aware, if we do decide to have this in the public arena, it would just be the oral recordings rather than, you'll get a picture. Yeah, okay. Okay, so that's my position. So I'm supporting that we deal with this notification of the RPS in non-public. Speakers to the motion, Kate and Hillary.
I'm happy to go into non-public at the moment, but I'm also contemplating at some stage that there would be an ability to ask to go out of public when it comes to the essence of the accepting the RPS when we've asked all of our questions. And I'm sure that won't, I mean, I know that some issues, but I haven't heard lots and lots of issues. So I'm hoping that we can actually, for the purposes of ticking off in the actual substantive motion, go out of non-public and into public in order to people can understand where we're coming from on the RPS if all of our other concerns are alleviated. Is that how you envisage it possibly happening?
I'm not sure how that would be managed because let's say it was during the debate on the recommendations, how would we manage individual comments around whatever topic?
Okay.
That would be my only, I'm not saying someone would say something that they shouldn't, but we've got no control over that debate from an individual basis. So very little control. So that would be my only nervousness. Sorry, I am conservative.
I understand why we have to go into non-public at least from the start.
Okay.
Mr.
Hillary?
Chairman, point of order, before we carry on going down this path. Okay. I've done this before in the last council and I was right. We got the legal advice and I'm going to do it again.
Just what's your point of order?
Okay, here, my point of order is this. The reasons given for us to take this into confidence today, into private, are not valid. In other words, I would argue we are about to commit an illegality. We now know from, so that's my point of order. And speaking to my point of order, we now know from Mr. Kelleher that the reasons why the first reason is there was not because of any threat or harassment to staff, but to elected members. Now, I'm not aware of any threat or harassment of elected members that has occurred to do with the RPS or has ever occurred in the history of the Otago Regional Council. So I question, all right, well, I'd be delighted to hear of it because I'm not aware of
Police.
The second is to maintain legal professional privilege, and we've heard Alistair Logan say, well, in actual fact, there's a distinction between what you're doing and what the privilege is. So I'm questioning the legality of in actual fact, the motion.
So you're wanting me to rule on that point of order?
Yes, I do.
I would like to hear a little bit more discussion on your point of order. Okay.
Okay, well, going to the first one.
Not necessarily from, you made your point. Sorry, Michael, what I should have said. Is there anything else you wanted to reinforce?
No,
I
I can't see that either of those two meet the test of the Act.
Any other, Gretchen?
We just heard from Peter Kelleher that it did make the test of the Act, which is why he put forward his reasoning that it should be public excluded. So, yeah, I don't agree with that.
Hilary?
I didn't hear Mr. Kelleher to say that. What I heard him to be saying was that the reasons given here are such and such, and you'll correct me, please, Peter, if this is not what you said, and that it was up to us to decide whether to do it or not. Now that is separate to whether it is doable. It's not whether we should do it. If it's not a valid ground,
that's what I'm
then the point is that it isn't up to us to just choose to do it or not. If it's not valid, then we haven't got that choice. Exactly and right. I don't think our advice from Mr. Kelleher was, it was that we could choose to do it. It wasn't that he was confident that that was a proper grounds in this case particularly, but just that these were the grounds presented and that we could make our choice. Is that right, Mr. Kelleher?
Thank you, Councillor. It might help if I paraphrase section 48, where it mentions that a local authority may by a resolution exclude the public from the whole or any part of a meeting only on one or more of the following grounds: that the public conduct of the whole or relevant part of the proceedings of the meeting would be likely to result in disclosure of information of which good reason for withholding would exist, where the local authority have such grounds under section 6 or 7. The grounds which you mentioned earlier on are 7. The Act reinforces it's for the local authority to decide, and I guess the triggers that are in the Act would be likely to result in disclosure of information where there's good reason to withhold. But so
are you saying? Sorry, are you saying that that section is, in your view, in this circumstance, reasonable grounds?
If I could start on the second ground in particular, we've got legal advice, a legal counsel in the council chamber at present. Legal advice would be given, and particularly for the legal advice part of it, very comfortable with the improper pressure on members of the council. Yeah, that information has come from staff where they said that is a risk, and that's why it's been put forward as a consideration for the council.
Sorry that I haven't ruled on your
thank you for the discussion.
I ask that the motion be put and second division.
I need to rule on the point of order. I suppose my feeling is that the staff have given a couple of reasons why that we should hold this discussion in non-public, but I think the reasons go well beyond the advice we've sought, and the ability for us to have that open and frank discussion on such a topical issue as notification of a regional policy statement, I think is additional. It's an additional reason to stay within non-public, and yeah, that's my view. So I don't uphold your.
So are you creating a third reason?
I'm just making that point that there are other reasons, including that one. So I don't uphold the point of order. So we'll go back to the debate on this, the motion that's on the table.
Yeah, I've got a procedural motion.
Oh, you said you had-
But I had,
Okay, beg your pardon.
you
Sorry.
had said I could speak before you asked.
You did speak.
You did,
just
and then
before
No,
spoke.
I didn't speak. I was answering, I was speaking to the point of order that Michael was raising. You did say that I could speak to the motion.
Okay.
Okay, no, that's okay. That's fine. If you speak to the motion, and then we'll take the let the motion be put.
And what I would like to suggest is that the mover and seconder of the motion contemplate a change to the motion saying that this will be released in its verbal recording within a fortnight or something, so as that we don't have outstanding there the thought that someday at a later point we might be able to make it public, but that we decide now, because unless we decide now as part of it, so I'm inviting the two of you to say, yes, it will be released, but not at the moment.
And my reaction to that would be that the chief executive has the delegated authority to make that call at the appropriate time and release the appropriate.
Yes, no, she has the delegated right to make that choice. I'm saying if we round the table say that this is what we will do, we can presumably do that.
And all I'm saying on the negative side of your what you're promoting, I'm saying that that's already in train. You're suggesting that we as elected members make that call, and I'm not comfortable with that. That's all I'm saying. Carmen, you may want to speak to that because the question was posed to you and me. You're okay?
Yeah, I'm fine.
Okay, so we're back to Brian.
Procedural. So I need a seconder. I'd like the motion to be read out, please.
And seconded by.
Seconding the procedural motion.
Thank you. So the resolution basically is that the public be excluded under Lagoima sections. I won't read out all those, but it's on your, it's on your audit paper.
Yeah.
For the discussions on the following item, RPS notification, noting that the external parties will remain for the discussion: Sandra McIntyre, Michael Bathgate from Akaha, Alistair Logan and Simon Anderson from Ross Dowling, Felicity Boyd from Insight, and Peter Constantine from Planright. Sorry, beg your pardon.
So just for the motion itself is to be public excluded.
Correct.
Yeah.
Correct. So I'll put the motion. Well, let's just go to a division.
Well, this is a procedural motion to whether we go ahead. Yeah.
Correct.
Well,
so we don't need
you can do that on voices.
Yeah.
Yeah.
Okay.
But the procedural motion included in it that we have a division.
Yeah, for the main vote.
But this is the procedural motion.
Okay. Procedural motion that the motion be put. Correct.
Yes, that's
all correct. Those in favour, please say aye.
Aye.
Aye. Against. So the motion be put, and that's the one I've just read out.
Yeah, and division.
And we're going straight to a division. Thank you, Di.
Councillor Calvert?
No.
Councillor Deaker?
Aye.
Councillor Hobbs?
Aye. What about Alexa?
Yeah, we'll go. Yep.
Yeah.
I can't actually hear Diane, so I don't know if you've called my name or not.
I'll just talk this back. Right. So sorry, can I do that again? Councillor Calvert?
No.
Councillor Deaker?
Aye.
Councillor Hawkes?
No.
Councillor Hobbs?
Aye.
Councillor Hope?
No.
Aye.
Councillor
Miss me out. In alphabetical order. Yeah, no, obviously.
Councillor Malcolm?
No.
Robertson?
I am.
No.
Wilson?
Oh, there you go. Is it tie?
Well, I never actually pick up what.
No, I've got a tie
Gary.
as well.
Gary, you was a no. Okay.
6-6. Yep.
6 all.
Yeah.
No, it's 6-4. 6-4?
6 all.
6 all. 6 all.
Yeah.
6 all.
Councillor.
Hold on.
There you go.
No, I've got 6 all.
Yeah.
So I've got Calvert, Forbes, Laws, Malcolm, Scott, and Kelleher opposed. That's 6.
Forbes.
Hang on.
Forbes has said no.
No. Yeah.
So it's 6 all.
6 all.
Could you reread them and we?
Sorry, Councillor Calvert, no.
Yes.
Councillor Dickey, yes.
Can you give Diane a microphone, please? I can't hear her.
Oh, his is not turned on.
Can you hear us now?
No, you did.
They've turned it off again.
Yeah, turn it off again.
Sorry, we'll come here. So we've got Councillor Calvert, no. Councillor Deaker, yes. Councillor Hobbs, yes. Councillor Forbes, no. Councillor Hope, no. Councillor Kelleher, no. Councillor Noon, yes. Councillor Laws, no. Councillor Malcolm, no. Councillor Robertson, yes. Councillor Scott, no. And Councillor Wilson, yes.
6
So
all.
that's 7-5.
7-5.
No, am I counting wrong?
Calvert,
2,
Forbes,
3,
Laws,
5,
Malcolm,
6, 7.
Scott. Oh, sorry, Scott.
Scott.
Kelleher.
Yeah, 7-5.
Sorry.
How did you vote, Brian?
So it's past 7.
You voted no, didn't you?
It's
Yes.
failed.
So it's failed.
Yeah, exactly. Yeah.
No.
So, yeah. So,
7-5 for the no.
so the motion is
Yes.
the motion is
Yes.
failed. Right. We stay in public. Okay.
Well, so I move. So we have, so we're just going to move into public.
Well,
But that's
No,
going to take a motion.
No, it doesn't.
All right, okay.
It doesn't. We're just in
We're
public.
moving on.
okay.
Sorry.
Okay. Welcome to all staff and so we'll just go back to the start. Welcome Felicity, Alistair, Anita, Peter, Liam, Simon. I think I've covered all the bases. In theory, anyone else that here can rest easy and feel comfortable that they can stay for the discussion. Okay, Sarah, I think you.
Sorry.
That's okay. That's okay. Sarah, you were going to introduce the report.
I am. And I think, yep, no, I can do that.
Okay,
Mhm.
we're in your hands. Thank
All
you.
right. Thank you, councillors. Obviously, we're in public and I hope that you will indulge me slightly. First of all, what I wanted to say was I really acknowledge the work that has gone into this and bringing the RPS here to you today, and not just the work of our own ORC staff, but also our iwi partners, Okaha, and all of the others who have been on our team, who have participated in the various sessions we've had around the RPS and had input, all of this Schedule 3 and 4 parties as well. So we're delighted to bring you the RPS today. And I just wanted to note some key things about the decision that you'll make today and what's important. So I do think it's important to note that the RPS has been prepared under significant time pressure, and as a part of that, we have really been grateful for the way in which parties have cooperated with us in good faith. In terms of operating inside of our timetable and the knowledge that notification was required and is required by the end of this month. And so that does mean that, you know, we've really put people under pressure, and I do want to acknowledge that. I think it's incredibly important. It's important to understand that the RPS is a regional document that deals with all of the environmental matters that have been identified through the process for the region. And it does guide the next level of planning that we have set out before us, and in particular the rule setting process for the land and water plan, which of course we have already commenced. Also, I just want to draw your attention to the critical reason for the imposition of the Minister's timeframe for the RPS. And it is so that we can have an operative RPS to inform the land and water plan by its notification. If we don't, there are serious consequences that won't just be for us as staff and council as we navigate having multiple documents at multiple stages throughout the building of the land and water plan, but also it will introduce greater complexity for our community and potentially uncertainty in terms of process, because we'll be continually having to weigh up different policy and also in terms of potential outcome. And this has the potential, if we have that uncertainty and we don't have the RPS operative in a timely fashion for our water permit holders. So I just point you to the guidance of the Skelton report and the Minister's recommendations, and the way that the time frame and where that this RPS fits into that time frame for our broader policy framework and for making our water policy particularly fit for purpose. You had Tamara May training, and as a part of that there was a discussion from the experts around around policy never being perfect. And it is really important, I think, to note that this is a moment in time, and the RPS has been prepared with that in mind, and that there will always be new issues that arise that we need to deal with, and that there are mechanisms that allow us to deal with those. If you do wish to add a new policy now, it does mean that we will have to repeat some of the process that we've been through. So that would mean that we would have to go back and revisit Schedule 3 and 4 and the consultative processes within those, and also amend the Section 32. And that does, of course, rely on the parties that we have worked with in our time frame. So I am mindful of the fact that the impact is not just for us if you should make such a decision. And I do think at best guess we would be looking at a 3 to 6 month delay. There is the opportunity for you to make a submission, or for council to make a submission on the RPS when it's notified, to deal with gaps or any other parts of policy that you think need further consideration. That is a process that's quite usual, is used by other councils and has been used by ourselves in the past, and it would help to avoid the delay that we would face if you didn't adopt the RPS today. I know that you're going to talk about particular issues today, and we're happy to advise you if we can on those issues. And lastly, I would simply remind you that you made a commitment when you accepted the Minister's recommendation on the time frame for this regional policy statement, and that should you not be able to adopt the RPS today for any reason, then he does have other intervention powers under the RMA that he may choose to exercise. And please, that is, I'm just making that plain. I haven't had any conversation with the Minister in this regard, so I'm not suggesting anything. I'm just trying to advise you that he does have other powers available to him should he feel he needs to exercise them. So it's a day of achievement for us. It's a day of achievement for the staff and for those parties who have been involved. And I do just want to make it known that we are incredibly proud of the work that's been done. and of the exceptional amount of dedication and effort that's got us to this point. Thank you.
Thank you, Sarah. Apologies, Gwyneth, that I didn't acknowledge you as part at the table as GM for Strategy, Science, Policy, and it'd be fair to say that it's a bit of a red letter day, you could say, for your team. So, on behalf of us all, thank you very much for getting us to this point, and obviously picking up on Sarah's comments around the work with our partners, Mana Whenua, through ACAHA and the stakeholders and the wider community as well. It's been a huge effort, so well done. So I'm going to go down to that end of the table. So I'm not sure whether Anita, Felicity, you want to make some general comments, and then we'll go to questions, and I'm sure there'll be questions around seeking maybe clarity on certain provisions.
Sorry,
And-
before we start, Mr. Chairman, and before we go that purpose, can I ask how you intend to handle the RPS when that debate comes up? So at the moment, as I understand, you're going through an information stage.
Yes, we'll go to questions.
Go to questions.
Questions
now,
first, and then I'd be looking for someone to move the recommendations. I'm more than happy to do that from the chair, and then we would go to debate. But, yeah, sorry, I should have made that clear. Anita.
I won't say much. I guess the paper is summed up asking two key questions of you. One, whether or not you adopt the Section 32 and therefore send it on a notification track, and then whether or not it's a freshwater planning instrument. That's what staff is here to get answers to. We're happy to answer any questions you may have, but they're the two substantive questions for today.
Excellent. Felicity, anything that you'd like to add at this point? Okay, questions, councillors. Marion, then Brian.
First of all, can I just say thank you? It's the most complex document that I've read in a while, because it's so balanced up against everything and counter affairs. God knows how you managed to dot all the I's. These questions are from a person who's not a lawyer and who may have been in charge of the RMA but never had to exercise it. The first one is, if I were to oppose a consent, so I'm an ordinary citizen, and the opposition, could I use the RPS, or do I have to use the actual land and water plan or the district plan?
The planning answer, it depends. The primary document that guides resource consent applications and decision making will be either the district plan or the regional plan under which the consent is sought. But under section 104 of the RMA, a proposed regional policy statement, so once it's actually notified, would be a matter that the decision maker could consider. Generally, the weight afforded to those provisions differs depending on where the RPS is in the process. It tends to be given more weight as it's gone through the process. But you would only be looking further up to the RPS if it was considered that the provisions of the plan were deficient or didn't address a matter such that you would need to go up the chain.
You can see where I'm heading. All right. Okay. The other one is integrated management. Sorry, love. If I was opposing a carbon forest being planted in our streams, could I use EM, P1 and P5 to argue against? I'm doing it by the E's. Sorry, I'll have to do it by the page. EM, that's in the first lot.
The page number, Mary?
I'm sorry, I haven't. I've done it all by the
So Hobbs, can you just give us the reference again? EM,
P1 and P5.
I think it's
IM.
Right,
So page 96 and 97.
Integrated management.
96, 97. Just remind us
Yes.
the reference numbers, Marion.
I'm sorry, I don't actually think that is there an EM in here?
No.
IM.
IM stands for integrated management.
I know what it stands
Oh,
for, I'm sorry.
I wonder what EM does.
I just wonder that it's quite a topical issue that Marion has referred to, and it may be useful just while Marion's looking for that number, Anita, in terms of just dealing with carbon forestry going forward. with
I am
this-
really
okay.
sorry, it is IM. I apologise. I was writing over the top of something and it made it into an E. Okay, it is IM P1 and P5. Sorry.
If you were a submitter and this RPS has been notified,
Yep.
then you can
The light doesn't work, I don't think.
Is that better?
We can hear you.
Yeah, sorry.
If you were a submitter on a resource consent application and this RPS had been notified,
Yep.
you could rely on, well, you could include reference to any provision of
Okay.
the RPS to support your argument. It would be the decision maker's
Sure.
discretion to weigh up
Okay.
whether that was relevant or not.
Okay. Thank you. I was trying to see if there was a wriggle room. Do you see what I mean?
Any other questions, Marion?
They only come up later on
Okay,
when we
thank
come
you.
to specifics.
Thank you. Brian, and then Michael Laws.
Actually, I moved my page now.
Oh, sorry.
125. Yeah. Look, I've got three intertwined questions about page 125 about the visions and management expectations. Yeah. And the first one is in relation to the dates. And, you know, like some of the dates are 2030, 2045, 2050. I see Manuheric is 2050. I see the Taieri FMU's 2050 and possibly others. If you could just give us some explanation for that, like without necessarily picking on the Manuheric care, you know, it's been through a time period of, let's say, non-natural use. You know, it was suggested it was 100 years, but just finished the 30 years in terms of mining privileges. And here we are in the RPS, another 30 years. If you could just provide some explanation for that. I've got a following questions with that. Thank you.
So through you, Chair, the timeframes and the visions reflect the complexity of the catchments to get to the vision. So the visions are not things that you can achieve overnight. The MPS requires them to be ambitious but achievable. And so that's why there's staggered timeframes. So things like the Catlins is 2030. There is less complexity. There are less issues to manage, less to resolve. The Manuheric care is more complex, requires more time, potentially requires more investment or solutions or whatever, as is the Taieri. So that's the reflection of the complexity of the issues, and the achievement of the visions will take longer.
Okay, thank you. Now, for example, with the Manuheric care, the 2050, and it actually talks about lots of different things to be achieved by that date, you know, flows in the water bodies, sustainable land and water management. It talks about, you know, contaminants to water bodies being addressed. So we've got an overall date of 2050, but how do you drive change now? Because it seems to me what's happened in the last 30 years is that, in fact, instead of necessarily improving the situation, it's actually been made worse. So how do we progressively ensure positive change to that date? And there may be some sub-dates, like water quality you might be able to solve on a certain time frame, water flow in another. So how do we drive that successfully?
So you're right. We anticipate that these end goals will be achieved through a series of staged goals or smaller goals that'll be set through the land and water plan. So that's the intention of the visions, is that then, so what you might do is say by 2030 we want to get to B,
Yes.
2040 to A, and then I've gone wrong. I should have started at C, but you get the point C, B, and then you get to the A, the end game by 2050. So the land and water plan is the vehicle to break that down and achieve that overall outcome.
Cool. So there's some detail yet to come underneath this.
Absolutely.
Thank you. And my final question, Mr. Chair, is for example on the Taieri FMU, there's no direct reference in regards to contaminants to water bodies for the Taieri FMU. Whereas, for example, for the Clutha, there is. Why isn't there?
The visions were developed on the basis of the feedback material gathered during consultation last year, which included feedback from Kaitahu Ki Otago and Ngaitahu Ki Murihiku. For the Taieri, the issue that came up time and time again was specifically wastewater discharges rather than contaminants generally. So that is why the Taieri vision focuses on wastewater, because that was the primary contaminant issue that arose in the discussions.
So does that mean that you've got license to contaminate?
No, so all of these visions start the same way, with requiring them to be managed in accordance with Te Mana o Te Wai. And in achieving Te Mana o Te Wai and healthy freshwater ecosystems, that is the baseline for all of these FMUs. So that's not a get out of jail free card. It's just an indication that in that particular area, that was a particular type of contaminant that was highlighted.
Thank you.
Can I just go back to Brian's second question around gauging, monitoring or ensuring effectiveness of policies? You are required, or we are required, to develop a regional monitoring strategy, which I assume that has something to do with, as it like a barometer in terms of improvement, etc. Is that?
So I was specifically referring to rules in the land and water plan. However, there is a method in here to develop an integrated regional monitoring strategy, so that could form part of that, absolutely.
Thank you. I think I've got Kate, then Michael Deaker on the list. Anyone else in the meantime?
I've got a question.
And then Michael Laws, then Gretchen.
I've got a series of questions, but I'll only ask two first up. And hi, body one. Can I just ask, and it doesn't worry me, I think it's really hard, but should we have given you, Diane, time to put us on YouTube now, since it's public, or is that on YouTube now?
I think we can't stand up staff to do that, so we're not live streaming. We are recording, and we'll put this on the website later.
And the only reason for that is because the paper was non-public. I'm thinking everyone thinks that anyone, if they were watching this on YouTube, understood what was in the paper, which, because that was non-public, they won't.
It will be.
Yeah, it will be. Thank you. Because I just wanted to understand that timing. Thank you. So the RPS, there's two questions I've got about the land and water plan and how it hangs off the RPS and what needs to be, or what powers the RPS gives to a council, for example, or restrictions it may give to a council. And if you could just work us through that. So you've just given an example of a timeframes A, B, and C for, say, the Taieri being in the land and water plan. Could you explain if something isn't in the RPS, how that will get into our land and water plan?
So the NPSFM has some bottom line, some things we have to do. So they're not necessarily specified in a level of detail in the RPS because it's not the place for them to sit. Councillor Scott just mentioned contaminants. There's a range of attributes that we have to meet in the NOF, the National Objectives Framework. They are default provisions, default limits that we have to have in the plan, but they're not mentioned in the RPS. The RPS also...
but they've got an NPS to hang on, so that's okay.
Yeah.
There's other things that don't have an NPS, that if they're not in the RPS, what weight can a council if they want to put a plan change in.
Can you give me an example of this sort of thing?
Carbon forest, if we want to manage that.
So the RPS directs us to manage appropriate land uses in appropriate places across the board. There will be some FMUs, I would imagine, where we might want to, for example, have more a closer look at dairy farming. There might be some where we would like to have a closer look at urban development. There might be some where we'd like to have a look at tree planting. The RPS provides us the vehicle to do all of those things as it stands now, but it doesn't specify a particular industry or type of activity over the other. The reasons we can do that is to manage water quantity and water quality in accordance with the RPS in our plans. So that those opportunities are available.
Thank you for the opportunity of sitting in both on I did the infrastructure one, but also in the FMU visioning exercise. I think it was really useful for all of us to be part of that.
Yeah.
I note that and thank you for the staff for making that available, that opportunity, because I think it really got us into the mindset of all of this. I sat in on one part of the Dunedin and coastal one where I got a very strong feeling that they wanted that separated out. Is there still, and that was suggested that it may happen in the RPS, is there still room for that if people submit? They still want it?
FMU boundaries?
Yes.
Absolutely. If it's in the RPS, it's available to be submitted on.
So even though those were set by councils 8 years ago, well before my time, and
not that long ago.
Yeah, well, not yeah, the work wasn't done. Yeah, and if they still have those views, even though that consultation didn't make a change in this version, that is something they should submit on now.
Absolutely.
Okay.
I'll come back to another one later.
Michael Laws.
A few. I'm sorry to bother you. Start with the easy ones. Can I take you to page 129 and the chapter that's headed fresh water? And ask a question of Alistair. Alistair, when the commissioners and or Environment Court come to interpret this section, as I'm sure they will in future times, can I ask you if the objectives are considered to be a guide to how they should interpret resource management applications and or district plans that might underpin this? So those objectives, would they be regarded as having a primary legal primacy? I guess is the word.
Provisions of an RPS have two roles. One is that they must be given effect to in subordinate planning instruments, so that's your regional plans and district plans. The objectives which you've referred to are outcomes which those plans should seek to achieve. So those provisions should be implemented where relevant in the regional and district plans. The second function of a regional policy statement is to influence the outcome of resource consent applications, notices of requirement for designation for public works and the like. They're not decisive considerations in those. They're matters which have to be given particular regard, and the weight that's accorded to them will vary depending on the strength of which the provisions are expressed.
One assumes that if they're an objective, then the aim of those subordinate plans will be that they give effect, in essence, is what you're saying, to what those objectives are.
Well, subordinate plans must give effect to the achievement of those objectives, yes.
So then can I ask you, if we go to natural wetlands, for example, well, no, we'll just take the first one as an example. In Otago's water bodies and their catchments, 1, The health of the Y supports the health of the people and thriving Mahika Kai, which, as I understand, means the gathering of food and other resources. Does that have primacy against those other objectives that are listed, 2, 3, 4, and 5?
There's no hierarchy. They're of equal status in that objective.
Okay, so if I was to read, for example, again, section 1, the health of the water supports the health of the people and thriving Mahika Kai, would I be working under the assumption that food gathering is in all of our water bodies is a primary objective of this regional of this regional plan?
Well, it's not a primary objective or sub-objective of those objectives.
Well,
they're all elements which are to be achieved through this regional policy statement. It's not, you've picked out objective 08, but there are other objectives under land and fresh water. There are other objectives which might be applicable in a particular context. When you're drafting a subordinate planning instrument or deciding a consent application, for example. But generally they should be interpreted and applied as driving to the same conclusions. So, for example, of the 5 matters there, they're of equal status and they're all things to be achieved.
Right. So 2 of those 5 discuss fish. Can I then take you to, and this is, you'll see where I'm leading to then question 2, which is restoring natural character. That's on page 132. And the headline is LFFW P14, restoring natural character. And then it reads, where the natural character of lakes and rivers and their margins have been reduced or lost, promote actions that, quote, 1, restore a form and function that reflects the natural behaviours of the water body. Now, I'm aware of at least, 2 hydroelectric dams, but also a whole series of other irrigation dams that are in connection with that, including the Falls Dam on the Manuhira Kia. Where does the Falls Dam fit there? If the aim of that is to restore the natural character of rivers. Because it would seem, can I just say it from a layman's point of view or interpretation, it falls nowhere. That in actual fact, this plan says you're required to restore the form and function that reflect the natural behaviours of the water body, but this is an unnatural behaviour because of Falls Dam having been committed there in 1932 or 33. I could think of other dams that for a similar purpose throughout Otago. So what are you meant to be doing with those dams then under our regional plan?
Well, there's probably a legal answer and a planning answer to that. I'll start off by addressing the legal element. Firstly, you've got to go back to page 129 and look at the objective there. The natural character of wetlands, lakes and rivers and their margins is preserved and protected from inappropriate subdivision, use and development. So there's a qualifier, inappropriate subdivision, use and development. And you need to read the regional policy statement as a whole to determine what is appropriate and inappropriate. And you'll find that there are provisions there relating to, for example, renewable electricity generation and the maintenance of existing generation facilities in this region. Falls Dam is used in part for hydroelectric power generation.
But that's future consideration. Can I just pull you up legally? The natural character is preserved and protected from inappropriate subdivision, use and development. So that anticipates something that's going either in the present or in the future, not the past.
Well, you asked me about something that was
That's exactly what I'm
created
trying
in
to
the
say.
past, so that's why I was
Michael,
addressing the
can I just
question
make a
that
comment?
way.
I'm not
Yeah,
gonna,
yeah, you go for your life.
I don't want you to pull Alistair Logan up legally.
Why?
He's he's our legal advisor, but
Cool.
legitimate questions around the particular meaning of different clauses, etc. No problem with that, but can we just keep it sort of at the high level where this document is, rather than drilling down into specifics? But I get your point. When there's existing infrastructure, you're trying to understand that connection. When it talks about natural character, how does that all mesh in, and is it really achievable, or whatever your point is?
Well,
Hone
maybe,
in on the question.
or maybe I'm asking the wrong person. I'm sorry, Alistair.
Well, could I just finish
you go for your life.
my response? Because I think it's also important to look at the words of P14, and that the lead-in concludes promote actions that
That's right.
restore. So it's not a mandatory direction. It gives the person who's influencing or implementing this regional policy statement a fair degree of discretion about when, how and where to undertake restoration actions.
Sorry, is that your understanding, Anita?
And if I could conclude,
Yeah.
as I said, you've highlighted one or two provisions and run a particular fact scenario past them.
Yeah.
I'm having to deal with this on the fly. You've
No, fair
obviously
enough,
had
fair
a
enough.
chance to think about it.
No,
but
that-
what I would emphasise is that you need to look at a particular situation such as you've raised in the context of the document as a whole. And I've singled out some provisions which I suggest might be applicable to putting this in the whole full context.
Anita, did you want to comment, or
Yep. Felicity's just going to provide you some planning context.
Okay. Thank you.
Yes, I mean, Alistair has picked up the main points. The header, the chapeau or the introductory line of this policy limits the promotion of actions to only where natural character has been reduced or lost, first of all. But also, as Alistair says, it is not a mandatory direction to undertake these actions. It's encouragement that where it's possible to do these things, we should be pursuing opportunities to do them. But it also recognises that there has been modification of water bodies across Otago, and in some cases, it is appropriate for those modifications to continue.
Any further questions, Michael?
Yes, yes. Can I take you to, well, the start of land and freshwater, and it's the explanation, page 123. It's essentially a creation myth, is being put into our regional plan. You may as well run Genesis chapter 1 verse 1 as well, I assume, at the same time. You'll see the creation myth that's there. Is this intended as a document that we want to have promoting scientific aims and objectives, but we're going to actually introduce a religious element or a spiritual element as well? And if we are actually doing that, why are we only doing one?
I'm not sure. I think I know where the question's going, and I don't want this to turn into a debate about the merits.
I have raised the issue.
Yeah, I
before.
know you have.
In workshop.
Yes, I know you have. But if it's about our obligations under the Treaty of Waitangi, or our obligations under Te Mana o Te Wai, or Kyoto Katai, in other words, Mountains to the Sea, all those principles, beliefs, values, this is not the place to have that
this is
debate.
Absolutely the place.
No. When there's clear direction at a higher level, where we have no, even if we wanted to, we have no ability to make change in that space. I'm not suggesting anyone wants to, but so I don't want the conversation to head that way. legitimate questions around the meaning of certain, whether it's an explanation or principal reasons or whatever. I've got no problem with that. Fair enough, Michael?
I don't agree with you.
No, I
The
didn't
Treaty of
think you were
Waitangi
going
doesn't
to.
say anything about spirituality. But I'm interested, I raised this issue at workshop, and I am really unhappy about the mixing of religion and state, and having what is essentially a quasi-religious or spiritual explanation for a rational policy contained in here.
Okay, so I'm going to ask either Anita or
But
Felicity
somebody can
just to
explain this to
give some background around the sorts of commitments this organisation has to deliver on some of those, that cultural.
You are now going to raise a real.
No.
Why don't I, do you want to address it just at the high level?
Well, fine.
But I'll start at the high level, not specific to the RPS, but specific to the partnership and the relationship that we have with Mana Whenua, Kaitahu in this particular case. So you have a strategic direction commitment that talks about bringing into our frameworks Mā Tauranga ki Otago, and therefore we have made a commitment to bring aspects of the Māori world into the way that we conduct ourselves in our work. Also, this piece of the RPS has been worked through with Kaitahu. This is their story to tell. It's not our story to tell.
And just to pick up on the planning aspects of that, under the RMA, it is a matter of national importance for the council to recognise and provide for the relationship of Māori and their culture and traditions with their ancestral lands and waters. So there is a statutory mandate to consider that relationship. Under the NPS FM, the council is required to give effect to Te Mana o Te Wai and to use that as the framework for managing freshwater. The National Policy Statement for Freshwater Management describes Te Mana o Te Wai, the Te Mana o Te Wai framework, as including 6 particular principles, one of which is manaakitanga, which is the process by which mana whenua show respect and generosity and care for freshwater. One of the other principles is kaitiakitanga, which is the obligation that mana whenua have to look after the environment and for freshwater. And that explanation in the RPS is an explanation of the Kaitahu ki Otago expression of Te Mana o Te Wai and the reasons why the expression of Te Mana o Te Wai in Otago is what it is.
I would understand that argument if it was exactly as you've described it. But this is not the case with this document. This document, in actual fact, is intended to guide public agencies, bodies, individuals in the interpretation of a statutory, of a planning document of this council. It isn't so if it is contained in here, a creation myth and an explanation of, then it is germane. We don't just adopt it because they think this is important. We adopt it because it is going to have relevance to everybody who in actual fact is responsible or is subordinate to this particular planning document. So it's not just, that's what they say, it's this is how you will act as a consequence.
If you look at it carefully with respect, I think you'll see that it has a particular function as being an explanation for the preceding objectives and policies. And that the rest of the document is structured exactly the same way, and that's consistent with all regional policy statements, the length and breadth of this country. And has been.
No, but see, I thought that's why I started with that question, because that then leads you to, sorry, and this is where it all becomes relevant. This is where it's not just a creation myth, just an explanation. The very fact that's in there, can I then take you to natural wetlands, LF FOW 09, page 129. And it says Mahika Kai and other mana whenua values are sustained and enhanced now and for future generations. I think it's a reasonable question that anybody in the public would ask, and certainly this governance member does, is what are those mana whenua values? And I'm assuming, therefore, that contain just a page over, or just a couple of pages down the line, an explanation gives you an example of some of those mana whenua values. We don't define what mana whenua values are in this document. It then leaves it open at some stage, surely, for an environment court or for some other august body to interpret what those mana whenua values are, because we haven't.
I think there's a question in there. And
Yes,
yeah,
I'm asking, what are the mana whenua values and why aren't they defined in this document?
It is not for ORC to determine what the values of mana whenua are, and it is my understanding that that has been upheld in the courts recently. The council has an obligation to recognise and provide for the relationship of Māori and their culture and traditions with their ancestral lands and waters, and that for Kaitahu is strongly linked to the provision of Mahika Kai.
Can we keep moving
Sorry,
on?
it's just questions.
Any other questions?
Yeah, no, that's fine.
I could just round out that last answer that Felicity gave in two respects. One is that there are a lot of values mentioned in this document which are not defined but are to be defined in subordinate plans, so that there's nothing unique about using the phrase mana whenua values. And secondly, and very importantly, as Felicity has said, the jurisprudence from the High Court and above is that it's for mana whenua to define the values and to do so in the way that they think is appropriate, not for the regional council.
So just to answer, just to answer that question then. So in other words, we're sustaining and enhancing something in our formal document that we don't know and can be defined by another party at some time in the future.
And typically, definition would be in subordinate regional and district plans, as it is for ONF, ONL and ONF values, for example, or where necessary and not defined in planning instruments through evidence presented at a hearing or environment court level.
Anita, you wanted to make it.
I was just going to say that the definition or the delineation of mana whenua values will come through the Land and Water Regional Plan. I was just going to say exactly what Alistair said. So that's the RPS provides the direction for ORC to do that as part of the Land and Water Regional Plan on an FMU basis, and that's a conversation that we would anticipate having with mana whenua as we develop the plan. And that's the nature of the RPS, is that it's provides direction to the lower order instruments.
Thank you. And this relates to the same topic.
Actually, so for our staff and, for instance, our catchment groups going forward, they will have a very strong definition of mana whenua to go with, that they can then set their direction on the operation of their catchments.
I can't tell you at this stage what the mana whenua values will be because it's not my decision to make. But what I can tell you is they will come through in the Land and Water Plan, and I imagine they may not be the same in every catchment, rohe, sub-catchment, because mana whenua interact and use the land and the water differently in different places.
And I actually didn't ask for specifics, but will those be included so the people in those various catchments will be able to act to them? Because at the moment we haven't got a specific definition in any catchment. So I'm just assuming let's say the Kakanui catchment, that Moeraki will come with us and put down what their basis of actions are so that we can work with them.
They will articulate their values. So I'm sure, looking towards Sandra and Michael for some confirmation that yes. Yes.
Well, it just makes the document unworkable if we actually don't have that, doesn't it? I mean, we can't give effect to their wishes. And I'm not arguing with it being in here. I'm just simply saying if we haven't got a list of criteria to work to, we could be going at completely opposite angles, couldn't we?
Kaitahu Ki Otago does have an iwi management plan that sets out in quite some detail around Otago what their values are. That plan is from 2005, so it is somewhat dated, and I imagine that there will be changes that have occurred within Kaitahu over the intervening period. But I think that we can't provide an answer about the stringency or level of delineation of those values when we are not the ones who will be responsible for articulating them.
Yeah, thank you. Gretchen.
Thank you. Yeah, just want to recognise first of all the importance of today, and just in terms of the style of questioning and where we are at the moment as well. We're the council. We have developed an RPS with the community through a lot of work we have with our communities, through visioning exercises with local communities, through forums on specific subjects, and many months, well, not many months, it feels like many months, it's actually been a short time that we've worked on this, but intensively and collectively, and we've got to where we are at the moment. And whilst questioning in detail can be interesting at this point, and we could pretend we're the Freshwater Hearings Panel, I'm not sure how useful that is actually going to be, although some questioning is useful, and particularly that we're in public, maybe it will be helpful for community who I would like to see being able to have a say soon, because we're notifying, to understand, I suppose, the document. But yeah, I'm not sure whether going around on a lot of detailed questioning at this point is helpful to the council. My question, I have got one, and it's hopefully not going to be detailed. I just want to, say, can we try and get them brief and high level if we can? The freshwater visions and management and the objectives, and actually it's quite similar to Michael's question that he started with, which was how do they fit together so that, for example, you've got your objectives that by 2050 you're going to do certain things, and you might, for example, in North Otago you're going to have Indigenous species easily migrating, and then as you go through into the policies, you've then got a policy that says also that Indigenous species are going to be doing migration and moving around freely. So what one would take precedence, the policy or the objective, and also in the policies you're going to be setting limits as well, I suppose. It says that you will set limits, so there'll be limits set for FMUs. What if those limits the community says that they would like something and they would like that limit before the 2050 or whatever? How does that all come together? Does the time frame indicate, okay, we all need to take a really long time to get to this limit, or could the community decide that actually they want the flow or the whatever immediately, or in 10 years or whatever?
Yes, no, it is our hope that if these deadlines are able to be achieved earlier, then the council will pursue those opportunities, particularly if that's an outcome that the community wants to achieve. And the Land and Water Regional Plan will be the vehicle for those community level conversations about what the aspirations are and what is an appropriate timeframe for achieving them. And certainly there's nothing in the RPS that would prevent. In fact, there's probably a lot that would encourage earlier timeframes being achieved if that was going to be possible within the communities. Oh, and in terms of how things, how the provisions work together, we have tried our best to ensure that there is a logical policy flow from objectives through policies and methods. Ultimately, you have to read the provisions as they are written. I would be surprised, although I'm not saying it's impossible, that there is a very obvious and large conflict between an objective and a policy. But Alistair might be better placed. I don't know that an objective or a policy has greater weight or not.
Well, in a sense, an objective has greater weight, but because a policy is intended to achieve an objective, it's a way of getting to that result that you've specified in the objective. So quite a lot of efforts going into ensuring that framework is achieved. Okay. One of the difficulties you've probably encountered in addressing issues such as the one Michael raised about the Falls Dam is the dispersed way that provisions are that might be relevant to a particular situation lie in this document as opposed to the conventional RPS that you're probably familiar with, and that's due to the necessity to comply with the national planning standards, and they trying to shoehorn provisions into the silos that mandate is very difficult at times, and it's easy to lose the threads.
Okay. Harry.
Thank you. My question is around, we've been through a very comprehensive process and we are under some quite unique time pressures dictated to by the Minister that might be not say typical to what other councils would be under in updating their RPSs. So the Minister has expectations of us. So we picked our key topics. We have engaged very comprehensively with our community in quite a unique way. And then a new issue appears, and the issue, of course, is carbon forestry. And so we have asked some specific questions, and the Minister has come back and said, you have the power to sort it out yourselves. So I guess my question is, given we are at this stage with a planning document, a very critical planning document, has staff gone back to the Minister and asked for some clarification around, would you have an expectation of that issue to be resolved within this document, given the time frame we are at, or the time we are at with it? Or is that being left to governors to actually make a call on that now?
I can answer that.
Sarah.
No, we haven't gone back to the Minister at all, primarily because Council passed a resolution on the 12th of May for 3 councillors to lobby on the issue.
I did.
So, no, we left that with governors.
Okay. Okay, no, I'll leave that for the moment. Thank you.
Okay.
So point of information. Just point of information.
Point of information.
Why not?
That novel, both the letter to the ministers and the answer was shared with all councillors.
Correct. Yes. Yeah. Thank you, Marion. Anita, did you want to touch on, now that we're talking about carbon forestry, in the existing, the partially operative RPS, we've got a policy and a method that sits in there that highlights this particular issue. Perhaps not in exact detail, but it certainly highlights the concern around dry catchments and potentially having an impact on a land use activity that could reduce the water yield, etc. Are you able to identify in this document in front of us today where the sort of provisions would impact on that type of land use activity?
So we've got a slide that we pulled together just before, so we can, if we can share it. Do you need it, Di?
It's on.
It's on this one, but I can email it to you if you want to share it, or what's the best way?
Yeah, that's not in the Zoom meeting, so I don't think it'll share on, it might share in here, but not.
Do we get this one up? Okay. Bear with. And then Felicity will just take you on a journey, excuse the pun, about that 2019 provision and where and why it appears now.
Yes, so I am aware of the policy in the existing RPS about managing land use change in water-short catchments to avoid significant reductions in water yield and the direction to control any expansion of forestry activities. There were three primary issues that I ran across when I was examining that policy. The first is that there is no associated definition of what a dry catchment is. I am aware from my work in Canterbury that Canterbury has similar provisions for what they term flow sensitive catchments, where the primary water source is from rainfall rather than snowmelt or that kind of thing. And in those catchments that are particularly sensitive because of their reliance on rainfall, they have a rule regime that attempts to restrict the amount of forestry that goes on in those areas, because the forestry takes a large, well, the trees suck up a large amount of water and it affects reliability of downstream abstractions. I spoke to ORC staff a number of times about what was intended by the use of the term dry catchments, and it didn't appear that there was a definition in mind. I wasn't sure whether the scope, it was raised during clause 3 consultation. Waitaki District Council raised that they were unsure what that definition, what a dry catchment was, and that it may encompass large areas of Otago unintentionally. The second issue with the policy was that it required the avoidance of significant reductions in water yield, but there is no further guidance on what a significant reduction is considered, and ultimately that would really need to be determined in your FMU processes, because that's where you set your outcomes and your limits, and you are talking about allocation. So in absence of knowing how much water there is and what the values are for those water bodies, and therefore how you need to manage them, it's difficult to determine what a significant reduction would be. So the result of my consideration of that policy and the feedback that we got was that the issue of carbon farming would be relevant for a number of provisions in the RPS, and a list of them is provided on the board. I would draw your attention particularly to objective LFLS 012 on page 137. That objective requires that the use of land in Otago contributes to achieving environmental outcomes as they are defined in the National Policy Statement for Freshwater Management for freshwater. So that is the first plank, essentially, in the requirement to manage land uses as part of our response to the National Policy Statement. Moving into the policies, LFLS P21 on page 138. That policy requires improving or maintaining freshwater quantity or quality to meet those specified environmental outcomes by, and in particular number 2, managing land uses that may have adverse effects on the flow of water in surface water bodies or the recharge of groundwater. And it's my professional opinion as a planner that that policy in particular would provide ORC with the ability to manage any kind of land use in its regional plan that may adversely affect water quantity. So that would include carbon farming, but it might include some other activity in the future that we're not aware of now that has that has adverse effects on water quantity, on flows, on groundwater recharge. The reason for taking out the specific wording about forestry was partly because there is an NES for plantation forestry that places restrictions on what councils are able to manage. The other reason was because the philosophy behind the land and soil section of this chapter was that we didn't want to be trying to pick winners or losers, if you'll excuse the colloquialism. The approach is the policy, the drafting approach was to recognise that there is significant work to come in the FMUs to identify the outcomes that communities want to see that are consistent with the NPS FM, and that achieving those outcomes is going to require land uses and possibly changes to land uses, but that we don't want to preempt now what those should be in absence of knowing what the communities want to achieve.
Can I just go back 2 steps to when you talked about the sort of 3 main reasons to get to your conclusion?
Yes.
And you talked about the significant reduction in water yield, which is in part of the existing plan provision in the RPS and in the current RPS, partially operative. So basically what you're saying, because there is no baseline, you can't actually measure a significant reduction. So in other words, you can't actually quantify what a significant reduction is. That's basically what you're saying?
Yes, I mean, for a consent officer at the council to determine whether, because essentially what the policy says is prohibit things that result in a significant reduction. So we would need to have some quantitative way of measuring what a significant reduction is. And at the moment, we don't have that.
So comparing what we've got up on the board, what we've had, and because of the lack of data to sort of deliver actuals on the ground in terms of influencing consent hearings because of lack of a baseline, etc. What influence will these policies have in light of the deficiency that actually exists through no fault of anybody's? Will these particular provisions have any greater grunt than what we've had currently, simply because there isn't a method and a rule to back up these provisions?
The new RPS doesn't include the direction to avoid the significant reduction because of the issues that we've already spoken about. The current RPS, in my opinion, strongly directs the council to manage land uses in a way that will achieve the environmental outcomes sought for fresh water.
Thank you. I'm going to go to Kate, Hilary, Marion.
Was Kevin in there?
Oh, sorry, Michael. We'll slip you in after Hilary.
I think Kevin was before me, that's all. Yeah.
There you go.
Okay, oh, so thank you. Look, thank you. I'm intrigued by this because we could have described dry. I understand exactly the difficulty you were in because the lack of what was in the previous plan. Would this be enough for a council, say Waitaki, if they've got a real issue with this, to hang their hat on and bring a land use rule in as a plan change to say we need to do this because we think that this area has, it's in the RPS, say the Kakanui may be in there as an area that's got over allocation and therefore water poor.
So Waitaki can't control water quantity, that's us.
No. So they can't put a land use rule in.
They can put a land use rule in for amenity or outstanding landscape or.
But they can't say under the RPS, we need to manage some land use to ensure that water quality is maintained. They can't do that, or they can.
No, they can't.
They can't.
So this means
that's us. That's ORC's role.
So the question then is, under the previous rule, the previous statement that was in or is still in there, if they could show that they had a dry catchment, and the Kakanui is an interesting one, that perhaps there is enough information to show that, would they have been able to hang anything under that for land use control? Under that, in order to ensure that?
No, their function isn't to manage water quantity, and that policy was around significant reductions in yield. So it's again, still ORC.
So, yeah.
So there's more in this to guide them, but it's not that particular provision. that one guides ORC in terms of the land and water plan, and that enables us to manage all sorts of land uses.
So is there anything that they could act on under this sooner than the land and water plan?
From what I understand, the issues with carbon farming are multidisciplinary.
Yes.
I have focused on what I understand to be the main issue for ORC to manage, which is the effect that trees have on water yield, essentially, in catchments. That is within the scope of the Land and Water Regional Plan. There are other reasons that territorial authorities may control land uses that are not for water quantity or quality purposes, but that may be relevant to
And so this
farming.
isn't it. Where are those rules? Where's that?
There is nothing specifically in the RPS directing territorial authorities to consider carbon farming, but there is, on the flip side, there is nothing preventing them, and there is nothing in the RPS that would prevent them from establishing those types of provisions.
So in this particular case, if I can just conclude the point, the methods envisaged regional plans will implement provisions, methods and rules included to give effect to the policy direction as opposed to district plans.
Okay, Kate.
Yep.
Hilary, then Michael, then Kim.
I think in that list of 3 things you said that were getting in the way of picking up sort of something like that and dropping it back into this process, you also said something about the NES that was already there. What concerns me is that essentially the NES and government directives is that we, broadly speaking, support trees and we want them planted and they don't have any resource consent issues. What we would like to do is say they do concern us because they suck up water, and that however people take water from at least some of our catchments, it matters. So what I'm grappling with here is where the NES fits in with our stuff. I mean, I think I understand the government can say, we are not going to make rules about having trees, plant them, whatever. And we can say, because of water issues, we would like to take some credence of or notice of or control in some ways where you plant them at least. Can we do that in a way that not so much overrides what the government's saying, but saying as a subsection of them saying anywhere, us saying except where we have water issues? Can we do that? And if we can, and these are part of the ways we can, then can we add on to one of these something that makes it a wee bit clearer? So without saying, incidentally, carbon forestry, this means you, can we add something that says water reduction, for example, or by way of either water takes or planting or howsoever, which allows us to make clear that it's not just water takes from pipes we care about?
There are a few things here.
Sorry.
The first is the distinction, I think, between carbon farming and plantation forestry. So the NES for plantation forestry defines plantation forestry, and it is forestry that has a commercial purpose and will be harvested. So it excludes carbon farms. So if the trees in plantation forestries and trees in carbon farms both suck up water,
are indistinguishable as a tree goes.
As far as the water resource is concerned, it doesn't distinguish between those 2 types of trees. The NES for plantation forestry does allow more stringent rules to be set if those rules are necessary for achieving a freshwater objective. So if you could demonstrate that it was necessary to control plantation forestry for the purpose of achieving the freshwater objectives set under the National Policy Statement because of the effects that it has on the water quantity, then the NES does allow you to have more restrictive provisions in your land and water plan.
And have we, for a start off? And then secondly, the fact that they're not plantation forestries are different.
Yes, so for carbon farming, the NES does not apply because it's not plantation forestry. And so therefore we're kind of freed from the restrictions of the NES, and the council can make rules in its land and water plan to manage land uses that affect water quality or water quantity. So you could manage carbon farming under the land and water plan, yes.
So where would we put in here any additional information that brings in those two different sorts of forestry, and they may be needing to be brought in slightly different ways, but it may not be because both those forestry uses are the same tree potentially.
So if we bring anything in here, we don't adopt today, just to be clear, but we also haven't looked at where you would put something in, because the question for today was whether you adopt or not. The distinction between forestry, and so we can be more stringent for forestry if it's to manage a freshwater objective, and we have an ability to be stringent about all types of farming under the RPS. It provides us, so the MPS provides us stringency for forestry, because forestry does have adverse effects on the environment, particularly when it's harvested, particularly around sediment. So we know there's a known issue there for forestry, and that's something that I would imagine as a council one of those issues would be looking to manage through our land and water plan, through our FMU process, is forestry, and where it needs to be more stringent. Carbon farming fits in that same set of something that we would want to manage, and we have the ability to manage in here as it is now, because it is a land use that may have an adverse effect on the flow of water in surface water bodies or the recharge of groundwater. It is that thing, so therefore we can manage it under the land and water plan.
So I invite the other part of that question that you've raised, which is you're saying we couldn't do it today by adding a few words, and I'm asking whether there are some words we could put in today.
I guess our staff advice is that we believe that you can manage carbon farming through the land and water plan with the provisions that we've listed here up on that list. That's what we're advising you today. It doesn't matter what land use it is. It could be carbon farming, it could be other types of land use.
Any forestry.
Any forestry, that's the list of provisions that we've pulled out that we believe that could be relevant, that we would guide us in writing our land and water plan.
Is that the legal advice?
That's my advice.
Oh, no, sorry. I heard your advice. I was asking as a secondary thing, from a legal point of view, is that what our legal advice would be?
Well, I think there is sufficient provision there to hang off rules and objectives, policies and rules in a regional land and water plan to manage the sort of situation that you're concerned with.
We've got a gap between now and when a water plan happens.
But we've got to remember, a regional policy statement is only objectives and policies. It doesn't have a regulatory effect in the sense of that rules do.
But it does guide territorial authorities and other things in the meantime, or not?
Yes, and these provisions, once notified, will.
Yes, so you're saying now, not just when the land, because you started that sentence with when the land and water plan comes out, we can put them in it.
Yeah,
so
well, sorry, I thought that's what your question was directed to.
If we adopt it today, that will be true for territorial authorities' choices and things.
Well, more importantly, our consent staff, if they were in a consent process, would be having regard to this if it gets notified.
Thank you.
Thank you. Michael Deaker.
Mr. Chairman, I was going to take you away from carbon farming, and you might want to stay on that.
I've just got one question to do with that.
Okay, can you hold that thought, sure, Michael, please? I'll go to Kevin and then to Michael Law's carbon farming.
So if there's no consent required, there's no action that we can take anyway. So at the moment, it's a permitted activity in the Waitaki district, so that just goes on unabated. You said that the issue around having the words was of dry catchments is that we could not define that, so it was unwise to put that that we can't put that into our RPS because we could not define it. Yet we hear, and rightly so, that you put mana whenua in there, but we can't define that. So I just find that difficult. Policy, we had policy, and I've asked 2 questions by email that I still don't believe that I've actually got an answer to that is sufficient, and that was from our 12th of May Strategy and Planning Committee meeting, and that was regarding paragraph 22 and paragraph 23 that did say that the draft RPS will be a similar suite of provisions and an integrated management chapter, and the partially operative RPS provides an ongoing ability for IRC to manage land uses, including carbon sequestration. And then also in paragraph 4 and 5, referred to the public recognition of forestry and carbon forestry issues. We know that the meeting actually recommended that we lobby government and ensured that we created rules in our land and water plan. However, we actually never determined anywhere to lessen the direction of our RPS. And if I understand our RPS, and that was on the advice of our staff, that the RPS gives direction to our land and water plan. So with the 2 very distinct policy and also the methods of 5.410 and the method of 3.116, I had a couple of questions. Was how can we demand that our land and water plan or territorial authorities district plans give effect to controlling the environmental effects of afforestation when that is actually not defined in the forestation that's not defined in the National NESPF, for an example, would be carbon forestry, and when our RPS doesn't have an overarching statement to do that. So I just have a great difficulty answering that when the advice that I've been given is that we have to have the overarching intent in there to give effect to.
You just state your question again, thanks.
Yeah, sorry.
Rightio. How can we demand our land and water plan or territorial authorities district plans give effect to controlling the environmental effects of afforestation when our RPS doesn't have an overarching statement? And this is afforestation that is not covered under the NESPF.
So as Felicity alluded to in her answer before, we haven't chosen any particular land use in the RPS. We haven't referred to that. We've referred to land use, and we haven't distinguished types of land use. And as I said before, those provisions that we've got up there on the PowerPoint are the ones that we've picked out that we would look to guide us in writing our land and water plan, which is where we're addressing the carbon farming.
And if I can just say, in my professional planning opinion, there is as much direction, if not more, in this RPS to manage carbon farming than in the existing.
Touch on paragraph 3 of that
It's
carbon
public excluded.
forestry report.
Yeah, it was public excluded.
public
So
Yes, it was. Yeah, true.
So we
And we are in public.
we opened
Sorry.
it up. Sorry,
Speak
the
up.
motion I thought after that was that we make it public. I had thought, we certainly made some motions that were public, that referred to it.
I think we've
Sorry.
made the resolutions public.
Okay, not the report. Thank you.
Sorry. Yep. Hold that thought. Kevin, are you sorted?
No, look, I'm not happy with that at all. We had specific reference in the RPS, in the existing RPS about dry catchments. We've now got no reference to dry catchments, and yeah, look, so we're hanging our hat on a definition that's going to be put in our land and water plan. Yet I've got no, I've got no idea what that's going to be, and I've got no direction from our RPS. I believe that is actually going to go, and I'm really disconcerted that that change was made after after we were assured that that was going to be in there. So I'm really struggling with it. I'm really struggling. I can take your advice. I can take advice that I'm going to have to read all those again, because I believe that on my initial reading of those, they didn't give us enough direction to have that. So I'm happy to take your advice and reread those.
I think Gwyneth's going to...
I just want to clarify something. I don't believe at any point staff have given advice that a specific provision under the, what are we calling it? Partially operative RPS would be cut and pasted into the proposed one.
And I was just going to reiterate, it was I wrote the paper and it was my advice. So Gwyneth's trying to save me from going under the bus. But the intention of that paragraph was never that the exact provisions would be carried through. In fact, paragraph 23 says a similar suite of provisions, which we've listed for you on the board, which we think are better to manage the activity, are in the RPS.
Yeah, the particular reference to dry catchments is gone.
Yes.
It is gone.
Yes,
and
that's correct.
Had I understood that to be the case on that day, I would have been arguing that be put into the RPS. Look, I'm not saying you intentionally did it, but I just feel completely misled in that respect.
The policy in the partially operative RPS, in my opinion, is not able to be implemented.
Yeah.
So the value of having it there is questionable, because there is no definition of what a dry catchment is or what a significant reduction in water yield is. So it would not be possible for ORC to implement that provision in the way that it is directed currently.
If you tried to rest upon that in a court, I think you would have difficulty.
I can't, because we're in public, but I could take you back to the legal opinion, and I agreed with that. But what we were saying, it is not hanging on the RPS, but it was hanging it on what was in our land and water plan, and that's where the definition came. Our RPS apparently gives direction to it.
So the RPS that you're considering about whether to adopt today or not provides more direction to manage this than the 2019 one. However, until the 2021 RPS is operative, then the 2019 RPS is still in existence. So we have both lots of provisions. So it doesn't go away, it's just not in the 2021 until it's operative. However, once it falls away from a planning position, my planning advice to you is that we have more direction to manage this in the 2021 RPS. A more robust foundation to manage it on than the 2019. But the 2019 RPS, the partially operative, is still alive, for want of a better word, until the new one is operative.
Thank you.
I guess we asked the wrong question, Anita. What we should have asked straight away is, how do we stop the inappropriate use of land in the Otago region for carbon forestry developments? That would have been the question, wouldn't it? And then we would have worked out a solution to that. Instead, we're sort of shoehorning. Can we see if we can shoehorn this into this conclusion?
With respect, I actually think that the question is, how do you manage all inappropriate land uses across Otago? And the answer has been consistently the Land and Water Plan, and the NPSFM is designed exactly to do that. That is the intent of it. That's the intent of the FMUs, is that you don't want to necessarily manage the same things in the same way in every part of Otago. So we want some delineation and some refinement.
The inappropriate use of land would,
it will come through that Land and Water Plan. I've identified a couple of types of activities that I think we will look to manage in some place, in some way in Otago. They are forestry, carbon farming, dairying. I can imagine that our plan, when we notify it in 2023, will have provisions around those. I can't imagine how we can't, because of the direction.
But in the meantime, and this is where my colleague's getting frustrated, in the meantime, we could be watching carbon forestry developing to a significant degree whilst we wait for that plan. And that's the frustration. So again, I'm going back to the question. is there anything in existing or in this plan that would stop the inappropriate use of land for carbon forestry development?
I think what you're asking is a rule-based question, because the way to prohibit an activity from, or to prevent an activity from establishing, is through a rule in a plan.
That's right.
This document does not have rules. So the deficiency in the framework is at the water plan level, because it does not prohibit carbon farming. And whether the RPS has strong direction on carbon farming or not, the water plan will continue to exist with its current rules.
So if you like, the gap will still remain, and there's nothing that we can do about it.
Not unless you want to change your water plan.
So we need to amend the water plan, the existing water plan.
Yes.
Which I think we might have had advice about.
Oh, there's a paper.
Well,
already have it.
process
of reviewing
We just remind you that you had a paper on the 12th of May, and you made a resolution on the 12th of May that directed us to deal with this in the land and water plan.
Right. So the water plan review process is happening as we speak. Michael Deaker.
Yeah, well, two things, Mr. Chairman. I noticed that Alexa has her hand up, and she may want to add to the carbon debate.
Thank you, Michael. It's quite hard to get noticed. I just want to say that I agree with staff on this, and I don't see why we're just picking on carbon because we happen to go and have a look at a really nasty bit of land use. This could happen for any sort of land use, and the rules that are in the, not the rules because there are no rules, the direction that's in this plan gives us the ability to put in rules into the land and water plan, and I am very happy with the way it is. I would love to be able to say, oh, no carbon farming around here, thanks, but that's just not what this is for, and nor should it be. What we're here to do is to put this framework in place, and you know, some of us might not like carbon farming, others of us won't like dairy farming, and you know, land use is land use, and putting a framework in to control those things. And it's not rules based, and I really think we need to move on from this. And I'm quite clear in here that we have provisions that can be addressed in the land and water plan.
Thank you. Apologies for not spotting your hands up.
That's all right. I know the systems aren't easy.
Michael.
Several
change
minutes
channel.
ago, I'm sure I heard staff say in response to Kevin that once we have adopted this RPS and it's publicly notified, then that will empower Waitaki
Oh, your microphone,
District Council.
sorry. Yeah.
Thanks, Gretchen.
Yep.
That will empower Waitaki District Council, if they choose, to make a specific rule in their district plan. Now, did I get that wrong?
They must actually give effect to.
Only they can only do it inside of the powers that and functions that they have. So we have provisions like the one we were discussing around fresh water. We are the only people who can control that. Waitaki can't go and make a rule about you can't develop here because you're going to impact fresh water.
Yep.
They can use our RPS where policies are relevant for their functions to take control of land use issues.
Anyway, Mr. Chairman, I did have a question, but before that, I want to preface it by going back to the opening comments that Sarah made about achievement and pride in her staff and all that sort of stuff, and say that I really want to endorse that and embrace that point of view. For a long time, this council had an RPS that was dusty and wordy and, well, who knows, because nobody ever looked at it really.
Yes, we do know that.
And the legislation at that stage didn't require anybody to ever go back to the RPS for any particular reason,
Michael,
except for a nostalgic wonder.
Can I take the liberty to suggest that you move the recommendations, because I sensed you're speaking to the.
Can we get Carmen back in here? I did have one more question I was going to ask.
have one more question?
But it was about carbon.
I'm happy to move the recommendations. That would be a privilege.
Okay, moved by Michael, seconded by Hillary.
Thanks.
That's my question.
And I'll just
Yep, you just
carry on with
continue
my
on.
brief comments and Kate can come back with her 40-second carbon question, whatever it is.
We've picked up quite a lot.
Yeah, but when the legislation changed and plans and district schemes had to give effect to an RPS, then we suddenly got into gear. And I want to acknowledge, along with what Sarah had to say at the start, the work that was done previously in a different life by Gretchen and by Trevor Kempton in putting together the 2019 RPS, because a lot of it still lives in here. And I'm pleased to see that, because boy, they worked hard at that, and so did other councillors with them, and of course a heap of staff, most of whom aren't here anymore. But that was an achievement, even though it didn't quite tick all the boxes. I wanted to add too to the staff acknowledgements that Sarah gave, because there were people that I saw throughout this whole process of putting this proposed RPS together, such as David Cooper and Sarah Ferguson and Lisa, who's somewhere on Zoom, and a heap of others who worked jolly hard out in the communities, doing sometimes difficult meetings, harvesting information, harvesting views for the visions and all that other stuff. And they did a hell of a good job, in my opinion. I want that to be on record as well. I'm delighted at the input that Okaha and their colleagues have had into this. It's really good to see our partnership manifest in a significant strategic document such as this proposed RPS. That's quite an achievement. We've come a long way, and we've still got distance to go. And I want to also acknowledge the work of God knows how many dozens of people on all those special interest groups. I think, Gretchen, you referred to those before, but I sat in on the Culture and Heritage and History group, and they had great discussions, and they beavered away and did a lot of homework, and it was good stuff. So we've come up with, I think, an admirable document. When it arrived, what is it, two Fridays ago, I got it out of its courier pack and sat down that whole Saturday and read the RPS. And I put myself in the chair of a district councillor or somebody who works at City Council, thinking, now I've got to give effect to this thing. Is it going to help me sort my thinking to see what regionally policies have to be given effect to? And the answer was a resounding yes. In fact, I was surprised at how tough this document is. There's a lot of musts in here. Not consider, not maybe, not think about, musts. And for the sake of our regional environment, that's the way it should be, and it's the way it's turned out to be. And that's an achievement. So I'm sharing Sarah's pride and the staff at the end of the table, their pride in having this document on the table, us about to adopt it. It's really good. Now, what is my question? It's a slightly pedantic one, but the one thing that frustrated me reading this was getting to the end of each chapter and finding a statement of principal reasons. How dumb is that?
Yes.
Why aren't they at the front of the chapter?
Because
just, I'm sure there's a good answer, but
the national planning standards require us to locate them where they're located.
well, they are dumb too. Yeah. If it's simply a formatting thing, they've got that wrong, and we should be telling somebody. So imagine how good this really would be if each chapter started with, what are we doing this for? Here are the principal reasons. It would be so logical, so clear, and it would flow beautifully.
So
you've heard enough of me, but I wanted to say all those things. There are more than I could have said. God knows, there's been enough talk this afternoon. So I'm happy to have moved the motion.
Excellent.
Thank you, Mr. Chairman.
Thank you. Just for Carmen's benefit, Hillary seconded the motion, so we're now speaking to the motion. However, there was one, I think the questions were complete apart from.
I'm going to deal with mine. I'd just like to note that I'm sure staff will love us before the end of the week to give them any typos we've found.
So can I just add that there's been 2 or 3 reviews since the version you've had, so all of the typos have been picked up, and we have delegation as staff to do what's called a clause 16.2. So if you do find some, flick them through. Hopefully we've already caught them, but if we haven't, that'll be really useful. But if you, just flick them through to me.
Thank you. So speaking to the motion, Marion, then
No,
Michael Laws. being Kevin. You're all good?
Yeah. We're now debating whether or not.
Yes, we are. So yes, yeah. So Michael Laws.
It's with a pretty heavy heart, actually, that I have to say that although this is a bit like the curate's egg, in the sense, and the thing that lets it down is this inability to create what I would consider to be a sustainable or explicable partnership with our iwi authority. And this is riddled through in this, which makes it indecipherable to somebody reading it. All documents that we produce should be so clear and explicable that the average 11-year-old could pick it up and read it and understand what it means, because that's the level of understanding that we seek to permeate through our community. But when it comes to explaining things, the explanation that we received, and I'm not critical of staff, that's the way it is that, well, we can't explain that because that's somebody else's control, and yet it's our document, and if we can't explain it, then what on earth are we publishing it for? I have enormous problems putting into one of our official documents, and no matter how good intention, nor no matter how culturally appropriate it might be, the religious or spiritual views of others, that just strikes me as weird and wrong, and inviting a response from the other treaty partner. And as I said, we could just as well put Genesis chapter 1, verse 1 in there as well, and covered off the other dimension perhaps, although then there are so many other cultures, we won't have to go through their creation myths as well. I'm not going to vote against it because it should go out there, but I'm definitely going to abstain. I am concerned that it's not a document that really speaks to our community in the way that it might, in terms of interpreting the needs, the views, the requirements, the imperatives, if you like, of our treaty partner. And so for that reason, I will abstain from voting on this issue.
There has been a heck of a lot of work going on in this and under a heck of a lot of pressure from everyone, and I congratulate everyone that's been part of that. And I also put a word out to our members of the public, as Councillor Dika already has. I really look forward to the day when we can read this document as one and not as our treaty partners and us, that we can have it fully integrated in one set of wording. Because that's where we should be at, and we should have it read that way. I would like to seek the indulgence so I can vote in favour of this, of my CE, or our CE, sorry, not just my CE, sorry, of our CE, that the appropriate planning staff take me through LF, the 10 clauses. Just to, and it's not doubting them at all, but I've clearly put them up a wee bit differently to what I thought. So I'd really seek that opportunity for you to advise me who I should talk to on that, because I'm sure that they have captured it. So I'm not doubting you. I'm just saying that I need that explanation. It is what it is, and it needs to be done. And thank you very much for everyone that was part of it, because it's going to get us. We have turned the corner. And it says that in this document, and we actually have to get that going. I will be really waiting for December 2023 for that final document that Mrs. Elsom has promised me that will be just absolutely tremendous. But that will only be tremendous if we all working together and make it tremendous. So I will be voting in favour of the motion.
Good, Brian.
Yeah, no, thank you. Firstly, I'd like to thank CE Sarah and Gwyneth and staff and other key stakeholders, iwi, everybody that's in the room and everybody outside of the room that's been involved. A big thank you. It looks pretty impressive. After saying that, I'm not an RPS expert, but when I read it, it looks good. What satisfies me is the process that we've been through. For example, when Professor Skelton first came and sat and we had some frank discussion and assessment, the fact that central government have been promoting national policies. The fact, as Councillor Deek or somebody said, we didn't throw the previous RPS away, we actually built upon it. The fact that we've involved key stakeholder groups and individual experts, this is all good. And when I read it, I see clarity around outcomes and responsibilities at the heart of the drafting style. I'm actually excited that iwi words are front and centre and part of this document, and we've given them the opportunity to speak as they see appropriate as our partner. Thank you. The integration of the RMA and the fact that we're doing work as a country in relation to the RMA, I'm really excited. Thank you. I'll be voting for this.
Thank you, Hilary.
I am not exactly of two minds, but I'll explain the two bits of my enthusiasm and lack of thereof. I'm very impressed at this document and how it's got to this point and what's in it. And I very much admire the putting it together and everyone who's taken part in it, and thank you. The other part of me, and partly why I particularly admire the way that this is put together, is that it is fundamentally a flawed process. What we've got is central government telling us what to do at all sorts of different levels and telling us to go and do it. And somehow they then want us to take ownership as if it's our idea. It's not our idea. It's interwoven central government policies that don't always sit together, and very good of our people to be able to try and put them together. Just as a little example of that, the Resource Management Act very clearly wants a Section 32 analysis, which of course we've got here, evaluation report, to be done whenever we do such a thing. And what the point of doing the Section 32 evaluation report is to weigh up, if we've got a proposal in front of us, like we have here, to weigh up the costs and benefits of everything we're proposing to do and whether there would be a better way of doing it. Alongside that, we've got the government saying effectively, forget about that because we're telling you what to do. And so instead of us saying what the costs and benefits would be, we find ourselves saying, or our people find ourselves saying, that the benefit of doing this is because we've been told to. And the cost of doing that doesn't really matter because we've been told to do it and we have to do it. It fits into another piece of paper that the government's produced. So in an ideal world, from my point of view, if the government wants to control us, which of course they can, and we are a creature of government statute in any case, they should just do it and tell us what they want to do, and we can carry out compliance things or whatever. As it is, they tell us what to do, and then we're supposed to in some way take ownership of and defend something that is not really our document in any useful way. Our staff have made a very good job, I think, of carrying out what they are obliged to carry out, mostly from central government directive and partially from as far as they could possibly do from input at a local level. But that's the best that could be done, and good on you for doing it. But we're not really players in this in any sense. We are just carrying out central government requirements. We've got to carry them out. It's worse even than usual because we've been told we have to do it by the 30th of June. So not only do we have to do what we're told, but we can't look at it. If, for instance, in the Section 32 evaluation, it said we should actually have more of a look about something, and we wanted to, the suggestion in front of us today is we couldn't even do that, which is what we're obliged to do under the Resource Management Act, because we have to do it by the 30th of June. So this is the last opportunity, first and last opportunity. So the whole thing is very awkward. It's led from central government, which, as I acknowledge, they can do. They should just have done the whole thing with our, I would have suggested our useful staff and people could have done them for them, but just leave us out of the process would have been easier. I will vote for it because really we don't have a part in the process, but today we need to do something. So today I will vote for it.
Gretchen, then Kate.
Yeah, no, I am excited today, and I think this is a reflection on community, and I think it's been said well already. But to be honest, I think the national planning standards have helped us to unwind our partially operative RPS from a complex, innovative document that actually ended up being quite difficult to implement, as we've spoken about today. So I think that the national planning framework has actually been quite useful. The short time frame, although pulling our hair out at times to meet that, has been really useful as well, I think. We are where we are. And we've got here, not by going off down a rabbit hole on our own in the dark. We've gone here. We actually, remember, we had a workshop where we brought in leading innovative approaches for how to involve community throughout the country. And we looked at those and we thought, how could we bring that into our own process? And we've got time-bound considerations, but we've tried to be as innovative as we can in working in the groups that Michael Deek had talked about. And then, yes, we did need to do some things like visioning with community. To me, that made sense as well. That was useful in terms of fresh water. In terms of, are we getting pushed around by the government? Probably, but successive governments have come up with an NES on fresh water, and the reason for that is that it reflects societal values. And so basically central government and local government reflects societal values, and we are where we are. And I actually think that our RPS reflects really well what our community's aspirations are, as it should. And I'm proud of being at the point where we're at, where we can now adopt and we can ensure that our stakeholders, communities and partners get to have a say. I could just let it go, but I can't on the comments about iwi and what's appropriate and what should be defined. You pick out any page in this document and try and define where we are. There's one about, recognising the importance of the provision of infrastructure to the social, economic and cultural well-being of the people and communities. So that is all people. And is it defined? No, it's not. That's the nature of an RPS. And we've talked about that at length today as well. We define further through other documents or other processes, as we've been legally spoken to about as well. I don't buy that argument. There's many things that could be further defined. It's important, very important, for the reasons we've heard legally and the reasons that we've heard of our own aspirations to weave right through this document the Kaitahu values, and they're here, and that's great to see. So thank you to everyone involved. Recommendations today are also around whether or not this is a freshwater planning instrument, and it's important that we address that as well. So in my mind it is, and it should be going through in entirety, because for the reasons that are given in the report, which are that freshwater is intertwined through pretty much all of the chapters, and trying to pick out which bits of freshwater and which aren't makes no sense. So put it through in its entirety would be my view. Thank you.
Cool. Well said.
Thank you. I think we've had some interesting debate, and I wish some questions had been answered last week to emails that we'd sent, but I don't want, and that's on the carbon forestry questions, and that's where it will leave, and something that's asked something to be avoided, whether it's well defined or not, or isn't, and the new plan will be something I'm sure people will argue as submissions, and that's where it is best laid. I do want to say thank you to the staff. It has been a very, very heavy load for the staff to do this in the timeframes given, and with new unexpected things added in with the freshwater. And to iwi for their contribution, because that has been huge. Thank you. I want to say, however, sorry
to all of those other parties have now doing third time RPS who are not paid to do any of this, who are now going to be submitting yet again on something that would have been nice if we'd got done once. And what more, are now waiting for land and water plan because the backbone, the RPS, has not been done. And I just want to acknowledge them, because there are loads of people who have given up time already on this one, who have submitted on the previous two, and they're often not acknowledged or appreciated. And they don't own the problem, but they wear it. And they there's a number of bodies, where there are heritage peak groups who have submitted and been involved in these things, whether it's iwi who have at every level have had to deal with this. I know whether they're community groups who just have aspirations for their water swimming hole and they're having to do it again. I just want to acknowledge them and say thank you and sorry, because I do think it's been a heavy burden on you, but I hope that we get it right this time and that somewhere we've incorporated your thoughts. And as someone who sat on the council and left the meetings frustrated in the previous instances, I think this is a heck of a lot better document, despite the planning structure that has been, doesn't necessarily give it, the numbering drove my head nuts, but I gather that's the standard, and I'm hoping that the standard may be proved wrong by the very nature, and some comment may go back from the freshwater commissioners. They've got a huge role to do to get this done and to get it done quickly, because we rely on it for the land and water plan. That is where the answers will come in the end, and the rules that we need them today. And the reason we haven't is not because the community have not asked for them. So I'd like to acknowledge the community and the costs that they may have in the next 2 years because we haven't done the stuff right in the first place. That is not owned by the staff. That the staff have changed considerably since then, and I'm not getting at any of the staff here. Thank you for the opportunity of getting this right now. Better late than never. Let's get going, and the sooner we get this done, the sooner the land and water plan will be right. Thank you.
Thank you. Look, I don't want to prolong the meeting any longer, other than just to say thank you again to the staff, as others have acknowledged. At that point exactly around the community, and we cannot underestimate the efforts that the community do have to continually go to submit with us, and how we need to value that. It's onerous on them. It is. There is fatigue out there towards it, and sometimes they may not be recognising the importance of the varying documents. But it is coming at huge cost to community too, where they are using professionals to assist them as well. So look, we have to get this thing out there. We're under time pressures. I think the one point I'd also like to make around the hour we lost at the start of this meeting, being in public, I think it is great that we have done this in public, and hopefully we have given a subtle message to the organisation that we would like to see more of this done in public, and hopefully we don't have to go through that sort of process again in the future. Thank you.
Thank you, Alexa.
You want to speak, Alexa?
Well, there's nothing really more to say, and I really agree with Gretchen's comments and pretty much everybody else's too. And I just want to acknowledge that it's been really difficult for staff, and the time frame was impossible. We've kind of done that. I also want to acknowledge iwi for their genuine engagement, and that's not been easy either. And it takes courage to bring what they've brought, and I'm impressed, and I like that. And I think we've got something that takes us further than we were and puts us in a better place than we were, and we've done it in the time frame. And thank you to everybody.
Thank you, Alexa. Carmen?
Just echo what Councillor Keller has said too. I'm not sure if this is working or not.
It was, yeah.
Oh, sorry about that. I'd also like to say that I'm sorry to those communities that we never got to when COVID came, and there were some meetings that we, it just had to be reshuffled, because what I did find was everybody had different aspects. They had different parts to their community that they wanted to share that were different from others, especially in Oamaru when we were there. We went to Middlemarch and Mosgiel and all those places around Otago, and that's what makes us so unique. So it's a shame we couldn't capture everyone. It's just the way it is, but thank you for putting this together. I found this quite hard to read, and it's not an offence. It's just I would have loved a little bit of something at one of them that said, look, I know you read one with the other. It took me a long, long time to get my head around, but thank you for it.
Okay, my comments, firstly, just going to the recommendation, I absolutely endorse what Councillor Robertson has said with regards to recommendation 2, that this proposed Otago Regional Policy Statement is a freshwater planning instrument, and I think of it as the land and water connection. It goes hand in hand. It doesn't. You can't sort of separate it out. One needs the other. They're naturally connected, and the decision-making process should be the freshwater planning instrument. I want to just go back to earlier on, or someone made the comment about it's a turning point, it's a significant document to have publicly released and notified to allow the community to feed into a submission process. And I think the ultimate for me is that we end up with a document that we can call the people's document, because that, I think that for me is the barometer. If we're able to have a high level framework that guides our region to good, sensible, sustainable RMA planning as we go forward, to ensure that we fulfill our obligation in terms of our guardianship for the environment. It has been a really, really tight time frame, and I sort of see the Otago Regional Council's planning policy commitments, science area, etc. It's like a jolly marathon, and we're under time pressure, and we're really actually only halfway, because if you look at the time frame, we've got another couple of years to be able to develop a land and water plan and have it sort of for preliminary consultation by about the middle of 2023. And it's taken us 2 years to get to this point after Prof. Skelton delivered his investigation outcome, and Minister Parker gave us the directions, which was October 2019. So we're still under pressure to deliver in the policy space. However, we're making really good progress, and it's really great to get to this significant point, which for me is about halfway. We've probably done 21 Ks of the marathon, but that's all good. Let's keep our head down. I think that the document, and Carmen's just touched on it, the previous regional policy statement wasn't an easy read or an easy to interpret. And I think this document is so much more user-friendly and less complex. That's the impression that I get reading it, looking through it. And the other thing I need to say also is that in terms of a significant step, I think we are the first regional council in New Zealand to notify an RPS giving effect to the National Policy Statement for Freshwater and also the National Environmental Standards for Freshwater 2020. So both those documents released last year, we are the first regional council to actually achieve that. So that's a significant milestone as well. And also just picking up on the iwi or mana whenua commitment that we have made in terms of partners, and also embracing and endorsing their beliefs and values through this document. It's embedded through the document, and I think that is also a significant milestone to achieve as well. That's probably pretty much it. I don't want to bore you anymore. No, that's me. So thank you all. Thank you for all your contribution. Thank you to the staff and everybody that's contributed on this journey. And we look forward to the submissions filtering in between now and the 3rd of September.
We maybe have a vote first.
Yep, I'm just going to put the motion in there. And I'm just going to make sure that I've thanked everybody, Sarah and everybody involved in this process. We really appreciate getting to this significant milestone. So I'll put the motion. Quite happy if I put the...
Chairman, quick right of reply.
Oh, sorry, absolutely.
That's all right. No, just there's been a fair amount of old fogeyism in the comments made in the last half hour. And as an even older fogey, I'd like to say that as the grandfather of a large number of kids in this region, I think 16 of the 22 live in Otago, and they're all of Ngāi Tahu descent, and they won't have a problem reading about Mahikakai or Wāhi Tāpuna, Tupuna, or Te Mana or Te Wai. They'll understand it better than I do. they'll understand the creation story is simply part of their whakapapa, and they'll be thrilled that it's acknowledged in a document like this. That's all.
Thank you. Are you happy that I put the five
Yes.
recommendations all as one?
Yeah.
Okay. I'll put those 5 recommendations. All those in favour, please say aye.
Aye.
Against? Carried.
You're noting my abstention.
You want it noted? Yep. Noting that Michael Laws abstained. That concludes the council meeting. Thank you all for your attendance.
Yeah. Because I want to commit to it. Got to keep the exit door open.